Introduction to Bankruptcy. This section covers the following: Overview on the different kinds of bankruptcies. Introduction to Chapter 7 Bankruptcy. Overview on Chapter 13 Bankruptcy. Changing a Chapter 13 bankruptcy to a Chapter 7 bankruptcy. Cost to file bankruptcy. Additional help. Quick overview on filing bankruptcy on student loans. Collection agency tricks. Wage garnishment. Garnishing your Social Security.
If you want to know how to file bankruptcy on your student loans, then go to our website.
Please hit subscribe or like. Thank you.
Overview on the different kinds of bankruptcies. Chapter 12 Bankruptcy is for family farmers or family fishermen, incorporated or non-incorporated. This is a repayment plan that lasts 3 to 5 years. The total debts from farming cannot be more than $3,792,650 and fishing $1,757,475. There are other requirements. Chapter 11 Bankruptcy is for businesses. Chapter 13 is a voluntary repayment plan that lasts 3 to 5 years. Chapter 7 Bankruptcy is a liquidation. This means that you will be able to get rid of all of your debts without having to pay any of them in the future. This video only covers Chapter 7 Bankruptcy. Answers to questions that most people ask. All we are going to do here is cover the basics for a Chapter 7 bankruptcy. For most people, this is all that they need. If you only have credit cards, medical bills, car loans, judgments, such as being sued, past due rent, etc., self-employed, and maybe own a home or have a mortgage, then this video may be all you need to file a Chapter 7 bankruptcy yourself. Once you file your bankruptcy petition, an automatic stay is in effect. The automatic stay protects you from all collection activities, garnishments, and lawsuit proceedings that your creditors would otherwise attempt. They must stop all collection efforts at once, including garnishment, and cannot contact you in any way, except through the court and your attorney. However, the bank may still have the right to foreclose a home mortgage or repossess an automobile. It is my opinion that if all you have are credit card bills, then do not file a bankruptcy. If you file bankruptcy, you probably will still lose your car and house. Under a Chapter 13, it is possible for you to keep your car or house. However, your monthly payment amount will probably increase. A foreclosure only lasts on your credit report for 7 years. A bankruptcy lasts on your credit report for 10 years. If the debt you have is 4 years old, then it will come off your credit report in another 6 years. If you file for bankruptcy, the time starts from day 1. So now, the debt will be on your credit report for another 10 years, for a total of 14 years. If the debt is 9 years old, means that you have 1 more year before the debt comes off your credit report. However, if you admit or imply you owe the debt will last for another 10 years on your credit report. If you do this method, remember, never admit or imply that you owe the debt, or the time period starts back to day 1, thus 10 more years. In fact, if the creditors call, just tell them you are not home or do not live here anymore. Chapter 7 Bankruptcy. A Chapter 7 bankruptcy is a liquidation. This means that you will be able to get rid of all of your debts without having to pay any of them in the future. This is called a discharge. However, not all debts are dischargeable. Debts that are not dischargeable are 1. Most taxes, 2. Domestic support and property settlements such as child support and alimony, 3. Court fines, penalties, forfeitures, and criminal restitution obligations. However, in some states, such as Illinois, parking tickets and red light tickets are dischargeable. 4. Debts that you do not list in your bankruptcy papers. Make sure you list all of them. If they are not dischargeable, then when you meet with a trustee, he will let you know. Trustee is the person from court overseeing your bankruptcy. 5. Debts from fraud or theft you committed. 6. Debts from intentional injuries that you inflicted. 7. Debts from death or personal injury caused by operating a motor vehicle, vessel, or aircraft while intoxicated from alcohol or drugs. 8. Debts owed to certain pension, profit sharing, stock bonus, or other retirement plans, or to the thrift saving plan for federal employees for certain types of loans from these plans. In addition, if you file for a Chapter 7 bankruptcy, the bank still has the right to foreclose a home mortgage or repossess an automobile. Plus, in a Chapter 7 bankruptcy and a Chapter 13 bankruptcy, the court can sell your stuff to pay off your debts. In general, you will lose any house or land you own when you file for a Chapter 7 bankruptcy, particularly if you're not current on your monthly payments. However, if you meet the requirements and live in the states of Florida, Texas, Washington, D.C., Arkansas, Kansas, Louisiana, Oklahoma, or South Dakota, you will probably be able to keep the house you live in if you file for bankruptcy. This is only if the house is completely paid off. No matter what state you live in, we strongly suggest that you talk to a bankruptcy lawyer regarding a mortgage or a foreclosure before you file. A mortgage or a foreclosure can be complicated, and to make sure your rights are protected, talk to a bankruptcy lawyer. Do not make the mistake of talking to just any lawyer. A lawyer that does not specialize in bankruptcy will probably not know all of the ins and outs of bankruptcy and will probably do more harm than good. Chapter 7 bankruptcy can be denied if most of your debts are consumer debts, and the court finds that you have enough income to repay these debts under a Chapter 13 bankruptcy. You have to do the calculations. The calculations will include, but not limited to, if you are married or single, the number of kids you have, how much it will cost to make your house safe to live in, car repairs, rent, religious contributions. Your living expenses have to be reasonable, such as you cannot be living in an apartment in the upper part of town, where your income says that you should be living in an apartment in the lower part of town. However, if you can show special circumstances that reduces your income or increases your living expenses, then you might be able to file a Chapter 7 bankruptcy instead of a Chapter 13. Important: if most of your income is from Social Security or disability payments, then you probably will not be able to file a Chapter 13 bankruptcy. You will have to file a Chapter 7 bankruptcy. Current monthly income for a Chapter 13 bankruptcy does not include income from Social Security or disability payments. Consequently, your income to make monthly payments for a Chapter 13 bankruptcy might be zero. Please see 11 U.S.C. Section 101, 10a-b. However, a judge might make you go through the steps of filling out all the forms for a Chapter 13 bankruptcy and then allow you to file a Chapter 7 bankruptcy. For this kind of situation, you will not have to pay any additional fees. If you file bankruptcy on your student loans, they will require you to provide 5 to 10 years of tax returns, bank statements, and pay stubs. In order to get rid of student loans, you have to go through an additional procedure. Overview on Chapter 13 bankruptcy. Chapter 13 is a voluntary repayment plan. The repayment plan usually lasts for 3 to 5 years and is designed to pay off all or most of the debts. Basically, all a Chapter 13 bankruptcy does is allow you to get caught up on past due debts. For example, if you are behind on your mortgage by $6,000, then a Chapter 13 bankruptcy will allow you to pay it over 5 years, or $100 per month, $6,000 divided by 60 months. Consequently, you just added an extra $100 per month to your mortgage payments. If you own anything of value, you will have to sell it or pay the value of it to the court. For example, if you own a car worth $6,000, free and clear, completely paid off, if you want to keep your car, you will have to sell it or pay the court $6,000 over 5 years, or $100 per month. The court will then use the money to pay your creditors. Another example. When they repossessed your car, you still owed $10,000. Then, they sold your car for $4,000. Thus, you still owe $6,000. In a Chapter 13, you still have to pay off the $6,000. If you are going through a foreclosure or are in a default regarding your student loans, a Chapter 13 bankruptcy may stop the foreclosure and allows you to become current on these loans. However, it does not discharge or pay off these kinds of loans. For student loans, you will still owe the full amount. In order to get rid of student loans, you have to go through an additional procedure. No matter what state you live in, we strongly suggest that you talk to a bankruptcy lawyer regarding a mortgage or a foreclosure before you file. A mortgage or a foreclosure can be complicated, and to make sure your rights are protected, talk to a bankruptcy lawyer. Do not make the mistake of talking to just any lawyer. A lawyer that does not specialize in bankruptcy will probably not know all the ins and outs of bankruptcy, and will probably do more harm than good. In general, the steps for a Chapter 13 bankruptcy are: 1. Fill out all the required forms, the Chapter 13 bankruptcy plan, and submit them to the bankruptcy clerk's office and receive a case number from the clerk. 2. Current and the past 2 years of tax returns or tax transcripts and 60 days of pay stubs. You can find the trustee office at www.uscourts.gov. You can get a free copy of your past tax returns from the IRS. Very important. Before you submit the form statement about your Social Security numbers, taxes, or pay stubs, ask the bankruptcy clerk's office if you should mail these to the trustee or file them with the clerk. Every state has a different procedure when it comes to this information. 3. Within 30 days of filing the paperwork, even if the plan has not yet been approved by the court, you must begin making payments to the trustee. You can find the trustee office at www.uscourts.gov. 4. Then you meet with the bankruptcy trustee to work out if the plan is feasible. 5. Then you go in front of a judge, and the judge approves the plan. However, it can take 3 to 6 months for your plan to be approved. Remember, within 30 days of filing the paperwork, you have to begin making payments by mailing the money to the trustee. So, have all the paperwork completed, and know for sure you can make the payments before you file the paperwork. The court cannot force you into a Chapter 13 bankruptcy. They can only not approve the plan. The problem is that many cannot complete a Chapter 13 plan and end up filing for a Chapter 7 bankruptcy. When this happens, you will have to pay an additional $335. Under a Chapter 13, you can cure a debt. This means that your plan will provide you a way of getting out of delinquency or making the debt current. However, this will probably increase your monthly payment amount. If you want to cure the debt, you must make protection payments before the plan is approved by a judge. The protection payments must be equal to the amount you would pay under the plan. However, this still may not stop the foreclosure or repossession of the car, and you will not get the money back if they do a foreclosure or repossess your car. If you do want to make protection payments, file with the court Form B1130, Motion, Notice and Order for Adequate Protection Payments, an opportunity to object. Then have the judge approve the protection payments before you make any payments. Costs to file bankruptcy. If you do it yourself, it costs about $335 to file Chapter 7 bankruptcy and about $310 to file a Chapter 13 bankruptcy. However, every few years they increase the costs. If you do not have the money to pay the costs to file bankruptcy, then fill out the form to waive the court fees or pay in installments. You can pay the cost in 4 monthly installment payments. When you file the forms to waive the court fees or pay in installments, you will go in front of a judge for approval. However, Most judges will not allow you to waive the court fees no matter how broke you are. The judge might give you 3 to 4 months to pay the full amount. However, once you file the bankruptcy petition with the form statement about your Social Security numbers, credit counseling, and personal financial management, all collection activities must stop. This includes wage garnishments. If after 3 to 4 months you still do not have the money to pay the court cost, then you can go in front of a judge and try it once more. However, if you do go in front of a judge once more, make sure you have a good reason why you were unable to pay the full amount. If the wage garnishment does not stop, then file a motion asking the judge to have the wage garnishment stop. Very important! Before you submit the form statement about your Social Security numbers, taxes, or pay stubs, ask the bankruptcy clerk office if you should mail these to the trustee or file it with the clerk. Every state has a different procedure when it comes to this information. Changing a Chapter 13 bankruptcy to a Chapter 7 bankruptcy. For people that filed a Chapter 13 bankruptcy and now need a change to a Chapter 7 bankruptcy, you will have to pay an additional $335 and prove your case to a judge. However, as long as you can pay something, no matter how small, a judge probably will not allow you to change to a Chapter 7 bankruptcy. If most of your income is from Social Security disability, or some other kind of disability payments, then you might be able to file a Chapter 7 because these kinds of income cannot be used to pay creditors. Thus, for a Chapter 13, your income might be zero or close to zero. Please see 11 U.S.C. Section 101, 10A, B for more details. For people that want to change from Chapter 13 to a Chapter 7, you will have to file a motion to change a Chapter 13 bankruptcy to a Chapter 7 bankruptcy, and certificate of service and notice of filing motion to change Chapter 13 to Chapter 7 bankruptcy, and notice of motion to change Chapter 13 to Chapter 7 bankruptcy. This will ensure that your case will not be dismissed for failing to follow procedure. Plus, you will have to pay an additional $335. We go over motions later. For any situation as this, we recommend that you talk with a lawyer first, because you will have to prove to the judge that you are unable to do a Chapter 13.
Please hit subscribe or like. Thank you.
Additional help. The best advice we can give is to contact your local bankruptcy clerk's office. Lawyers have to do this, and spending 5 minutes talking to the clerk will save you a lot of time and headaches. The clerks cannot give you any legal advice. Only a lawyer can do that. Many bankruptcy courts have free bankruptcy lawyers or a free help center that will help you with your bankruptcy. Spending 30 minutes talking to one of these lawyers will save you a lot of headaches. All public libraries should have free internet access for the public. Thus, you can go and use the internet at your local library. All colleges and universities have to provide times where the public can have access to their libraries if they receive federal funding. This includes community colleges and trade schools, and they should all have internet access. This means access to their law library as well. We do not know of any private or public college or university that does not receive federal funding. Call first to see when their library is open to the public. If you need more help, contact a bankruptcy petition preparer. They cannot give you any legal advice, but what they can do is help you fill out the paperwork and help you submit the paperwork. They are a lot cheaper than a lawyer, and some might charge a small fee for only typing up the paperwork, or a small fee to check your paperwork. Quick overview on filing bankruptcy on student loans. Yes, you can get rid of your student loans through a Chapter 7 or a Chapter 13 bankruptcy. First, you have to file for bankruptcy, and through additional court proceedings, you may have to prove that paying the student loans will cause you undue hardship, or you cannot maintain a minimal standard of living if forced to repay your student loans. This does not mean that you have to be disabled. This does not mean that you had to have made a payment. This does not mean that if your monthly payments are zero, you will not be able to get them discharged. Some loans in default may still qualify. Basically, you have to prove that for the next 5 to 10 years, you will not be able to make a minimal monthly payment. Plus, show that 1. You have not lived an extravagant lifestyle while failing to pay the loans. 2. You have not intentionally created your financial hardship. 3. You have not willfully arranged your financial lifestyle in order to avoid your responsibility for the loans. When it comes to discharging student loans, the courts are all over the place. There is no way to predict what courts will or will not do. However, the student loan section will give you some guidance on how to get around some of the tricks that are used to deny you. There was a woman that had a job. Her husband had a job. They had 2 kids and a mortgage. She was able to get her student loans discharged. There was another woman that was receiving Social Security disability for 8 years. She worked a part-time job every now and then. The courts denied her a discharge on her student loans. There is a form called Disability Discharge Application, or Total and Permanent Disability, that will get rid of your student loans if you are receiving Social Security disability, or if you have a doctor saying that you are total and permanent disabled. Please see section called Social Security, Student Loans, and Income Repayment Plan for more details. Most do not know that the government can garnish your Social Security benefits to pay your student loans. However, if you are in an Income Contingent Repayment, ICR, plan, then you should be able to get around this. We will go over an Income Contingent Repayment Plan in the student loan section. Married. If you want to make sure that one spouse keeps good credit, then one spouse can file bankruptcy and the other one does not have to. However, filing separately in community property states such as Arizona, Washington, Wisconsin, California, Idaho, Louisiana, Nevada, New Mexico, and Texas might not make any real difference because in these states, there is no separate marriageable debt. This means that if only one spouse files bankruptcy, the other spouse will still owe the debt. For a marriageable debt, you both have to file. Marriageable debt is debt that you attain during the marriage. It is not any debt that was attained before the marriage. For student loans, it does not matter what state you live in or whether the student loans were attained before the marriage. The court will look at the income of both spouses. Collection agencies' tricks. If you want to stop the creditors from calling without filing a bankruptcy, then all you have to do is send them a certified letter with a delivery receipt stating the following words. A certified letter with a delivery receipt only costs a few extra dollars. I am executing my rights under the Federal Law 15 U.S.C. 1692C for you to stop all communication with me, except for reasons set forth under this law. In addition, this letter is not an acknowledgement that I owe any debt. The part that says this letter is not an acknowledgement that I owe any debt is very important. If you state or imply that you owe the debt, the clock resets to day 1. For example, if you owe a credit card debt and you have not paid it for 9 years, then in 1 more year it comes off your credit report. However, once you state or imply that you owe that debt, then it will not come off your credit report for another 10 years. Just because you sent them this letter does not mean that they will follow the law and stop harassing you. However, with the delivery receipt, you got some proof that you did send them the letter. This will be helpful when you report them to the U.S. Department of Labor for harassment. Another trick that they use is to sue you in court and send you a summons for you to show up in court. Once you show up in court, then they can ask where you bank and where you work. Once they have this information, they can take money directly out of your bank account and garnish your wages. A lot of people have figured this out and now do not show up to court. For civil cases such as this, it is not illegal not to show up to court if you receive a summons. For criminal cases, it is illegal not to show up for court if you receive a summons. If you do not show up to court, all it means is that you will automatically lose. This will also reset the clock back to day one. These collection agencies are now conducting court by phone. These agencies really want to know where you are working and where your bank is so they can take money directly out of your bank account and garnish your wages. If you know you're going to lose, then when the court calls, do not be at home or do not answer the phone. Wage garnishment. It is illegal for the collection agencies to take more than 25% of your paycheck or 100% of the money in your bank account. However, if the garnishment is for child support, alimony, or taxes, then they can take up to 50%. One person we met was out of work for 2 years. When he got a job, put his first paycheck into his bank, they took it all. According to federal laws, this was 100% illegal. But the collection agencies know that most people do not know this, or know how to fight it. Plus, how are you going to fight if you don't have any money? If you make less than $217.50 per week, then no garnishment is permitted, other than for taxes, child support, and alimony. Please see the Debt Collection Improvement Act and the Higher Education Act, Federal Laws 31 CFR 212.8, 31 CFR Part 212, or 42 USC 407A. These laws say that they must leave you money to live on. These collection agencies also know that the company you work for probably doesn't know the law. This is why they tell the company you work for and not you. It is not enough for them to only tell the company. They must tell you before the garnishment begins, or it is an illegal garnishment. These collection agencies also know that most banks do not consult with their legal department and just do what the collection agencies ask. These are just the branches of the bank, and not the bank corporate office. If your wages are being garnished, and you did not receive a notice in the mail before they started to garnish your wages, then it is an illegal garnishment. If it's an illegal garnishment, then the Department of Labor will require them to give you all the money they took and may stop future garnishments. For illegal garnishments, contact the U.S. Department of Labor. www.wagehour.dole.gov. U.S. Department of Labor, Francis Perkin Building, 200 Constitution Avenue, NW, Washington, D.C., 2021-0, 1-866-4 U.S. Wage, 1-866-487-9243, TTY 1-866-487-9243. Garnishing your Social Security. When it comes to garnishing your Social Security to pay your student loans, will be reviewed in the student loan section. Your Social Security cannot be garnished to pay your debts. However, your Social Security can be garnished to pay taxes or child support. However, there is a loophole that will allow them to garnish your Social Security to pay any debt. The loophole. If you put all your income into one bank account, including your Social Security, then they can take whatever they want out of that bank account. However, if you keep your Social Security in a separate account where no other money is ever deposited into this account except for your Social Security, then they cannot touch your Social Security. For example, if you have one checking account where you have your Social Security directly deposited and then you find $1 on the street, you put that dollar into your checking account, and now they are able to garnish any of the money you put into that checking account. Thus, you need to have one bank account that is only for your Social Security. Plus, you don't have to put your Social Security into a bank account. You can ask Social Security to provide you with a debit card. After you have a bank account that is only for your Social Security, then you need to write the bank and the credit card company and tell them that this account is only for your Social Security. As it relates to the following laws, they cannot garnish your Social Security. Federal Laws 31 CFR 218.8, 31 CFR Part 212, and 42 USC 407A. For student loans, there is an additional simple and easy procedure you have to complete to stop the garnishment. We will review this in the student loans section. People have done many of these methods, and the garnishments have continued, and the collection agencies keep calling. All may be illegal, but they know you have no money, so you cannot take them to court. However, if enough people complain, then the U.S. Department of Labor may put a stop to it all. For illegal garnishments, contact the U.S. Department of Labor. www.wagehour.dole.gov. U.S. Department of Labor, Francis Perkin Building, 200 Constitution Avenue, N.W., Washington, D.C., 2021-0. 1-866-4 U.S. Wage, 1-866-487-9243. TTY 1-866-487-9243. Foreclosure. No matter what state you live in, we strongly suggest that you talk to a bankruptcy lawyer regarding a mortgage or a foreclosure before you file. A mortgage or a foreclosure can be complicated, and to make sure your rights are protected, talk to a bankruptcy lawyer. Do not make the mistake of talking to just any lawyer. A lawyer that does not specialize in bankruptcy will probably not know all of the ins and outs of bankruptcy and will probably do more harm than good. Terms. Pro se means without the assistance of an attorney. Co-debtor means co-signer. Discharging means getting rid of the debt. Exemptions. They are what you get to keep. There are two types, federal or state. Some states only have state exemptions. Some states only have federal exemptions. And some states have both. In states that have both, you are only allowed to use one or the other. Federal non-bankruptcy exemptions. These are exemptions that you can add to your state exemptions. Homestead exemptions. These are exemptions that will allow you to keep part of the value of your home. This ranges from $1,000 to unlimited. However, this depends on the state. Wild card exemptions. These are exemptions that can be applied to almost anything you own. Schedules are the paperwork that you have to fill out and submit to the court. Personal property are money, stocks, furniture, cars, jewelry, or old pair of jeans, anything that is not real property. Real property are land, houses, buildings, parking lots, outhouses, or any structure that is permanently attached to land. Joint property is property that both the husband and wife own together. Community property. You both are responsible for all debts you or your spouse acquire during the time you were married. This means that there is no separated debt for either spouse. In other words, if you get divorced and he files for bankruptcy, they will come after you. However, this is only for the states of Arizona, Washington, Wisconsin, California, Idaho, Louisiana, Nevada, New Mexico, and Texas. Lien. A lien is a debt that will not allow you to sell the house or car until the debt is paid. Lien avoidance means discharging part to all of the debt on your home or car. Trustee is a person that the court appoints who is paid a flat fee and by commission for finding any property that you attempt to hide. Motion is a form you file asking the court to do something. For example, you can file a motion asking the court for more time or to consider new evidence, etc. Amended are the papers you filed to correct a mistake you made earlier. Example, you forgot to list all your creditors or forgot to list all your assets, and then you file an amended. In some states, if you file an amended document, form, or schedule, you might have to pay an additional $35. Disclose. This means telling the court everything. Remember, when you file a bankruptcy, you have to list all your creditors and everything of value that you own. Necessities are the stuff you need to live on, such as food, clothing, shelter, etc. Tools of the trade is anything that you use for work or use to make a living. This could be anything such as a TV, work tools, a car, or a computer. Equity refers to how much a property that you own, tools, houses, cars, etc., after you subtract how much you owe. Example, you use a loan to buy a car. The car costs $10,000. You have paid off $2,000. Thus, you owe $8,000. Therefore, your equity is $2,000. However, the market value of the car might only be $6,000. You could find the market value of almost any car in the Kelley Blue Book. You can get a copy of the Kelley Blue Book at any public library or on the internet at www.kbb.com. Market value is the money that you will actually get if you sold it. Assets are anything that you own that is worth money. Priority debt means that you have taken payment for a product or service you still have to provide. For example, you have taken a payment for painting somebody's house, but you have not done it yet. This can also be child support, taxes, governmental fines, etc. Lessor, such as the landlord. Lessee is the person that receives the lease, such as the tenant. Cure a debt. Under Chapter 13, you can cure a debt. This means that your plan will provide you a way of getting out of delinquency or making the debt current. However, this will probably increase your monthly payment amount. Adversary proceeding is a legal proceeding that is filed in a pending bankruptcy that takes all formalities of a lawsuit. This includes a trial before a judge. If you attempt to discharge any educational loans, student loans, you will have an adversary proceeding. This comes after you file an adversary complaint. They do not make it easy to discharge student loans.
Please hit subscribe or like. Thank you.